Okay, welcome to a new deep dive. We've got a really intriguing stack of sources today sent in by you, our listener. It's a fantastic mix, giving us a snapshot of some major conversations happening right now.
Yeah, it really covers a lot of ground, doesn't it? Everything from, constitutional law here in India,
Yeah.
looking outwards at global diplomacy, energy policy, regional stuff, and even AI.
Exactly. And the sources come from different sections too, editorial, opinion, text. So we should get some varied takes. Our goal really is to unpack these and pull out the key insights for you.
Sounds good. Let's jump in.
All right, starting with the editorial section. First up, an article by Fazan Mustafa, Campus Free Speech and Constitutional Limits. This one gets right into that tension between free expression, especially on campus, and, well, potential limits.
It does. And interestingly, he starts way back, mentioning John Milton, Areopagitica in 1644, arguing against pre-publication censorship, that whole licensing system.
Right, the idea of needing permission to speak. The author kind of asks if some current pressures feel a bit like that creeping back in.
Yeah, and he poses some really fundamental questions like, are teachers just supposed to be robots without opinions? Is free speech, essential for dignity? Is truth still the main goal?
Or are restrictions based more on this idea that the state always knows best? It's a vital debate, especially considering India's World Press Freedom Index ranking isn't exactly stellar.
The piece does acknowledge the other side, arguments about national security or needing unity, as reasons some might give for wanting
But
restrictions.
a core point he makes is pushing back against labeling opinion, even dissent, as just activism.
Hmm.
He points out universities have a history of academics being engaged publicly.
Absolutely. And the central argument seems to be this. While individuals should obviously use disclaimers, say, these are my views, the institutions themselves shouldn't restrict speech beyond what's already in Article 19.2 of the Constitution.
Even for private universities.
Yeah, he argues that principle should hold. He mentions court cases that have treated private universities like state entities because of their public function, essentially saying education isn't just a business.
So why is this freedom so crucial then? The article hits on those classic points, the search for truth, like Milton said, letting all ideas clash.
The marketplace of ideas concept, right?
Mhm.
And also enabling citizens to form opinions about government, participate in democracy, just as Holmes's idea.
Now, the Constitution does allow restrictions under Article 19.2, but they have to be reasonable, and for specific reasons, public order, security, friendly relations with foreign states, sovereignty, those have been added over time.
And the courts have tests for this. It needs actual legislation, not just an order. And this doctrine of proportionality, does the restriction fit the problem? Is it the least intrusive way?
There's that case mentioned, Anuradha Passan, connecting internet access to free speech, where the court said the state has to prove restrictions are necessary and minimal.
Right. So the implication for academics is huge. If speech isn't protected, you're exposed. If it is, the author argues, institutions shouldn't disown the writer. It hits morale, recruitment, everything.
His bottom line is pretty stark. No institution has any right to restrict anybody's freedom of speech on any ground other than those mentioned in Article 19.2.
So for you listening, this isn't just some academic ivory tower debate. It really shapes the flow of ideas in society, what gets discussed, what doesn't. It's about the health of that whole marketplace.
Okay, shifting gears now, but still in the editorial section, let's look at India's Gateway, UK-EU Reset Impact by Vipin Beni. This one looks at the relationship between the UK and the EU potentially warming up again and asks, what does that mean for India?
Yeah, it's an interesting angle, a sort of Eurocentric shift, but with potential knock-on effects for India. The article talks about this potential reset under a new UK government, maybe more cooperation on things like trade standards, defense.
And why should India care? Well,
Mhm.
both the UK and the EU are massive partners for India, trade, diplomacy, you name it.
Exactly. So if they start aligning more, it could actually simplify things for Indian businesses exporting to both regions. Maybe boost supply chains, open up avenues for strategic alliances, even affect things like student mobility or diaspora opportunities.
Let's break down the trade part. India sends billions worth of goods to both places. Post-Brexit, dealing with two sets of rules, especially for things like pharma or textiles, has been, well, a headache.
So harmonization, if it happens, could mean less red tape, lower costs. The article uses the example of generic medicines. India supplies a huge chunk of the UK's needs. A unified approval process, that would be a big help.
Though there's a flip side mentioned, common standards might be tougher for smaller Indian businesses to meet. Needs more investment, maybe more know-how.
True. It underscores why those government support schemes like RODI-TEP or PLI are important for domestic firms.
Beyond trade, what about the bigger picture, geopolitics?
Well, if the UK and EU coordinate more on foreign policy, especially, say, on the Indo-Pacific, that could open doors for India. We already have strategic partnerships with both, covering cyber, climate, maritime security.
So, more joined-up thinking there could mean stronger support for India in places like the UN or G20, and maybe deeper defense ties with key players like France, Germany, the UK.
Potentially, yeah. Especially given shared concerns about China and the Indo-Pacific, it could lead to more trilateral or multilateral cooperation and, amplify India's voice as a leader in the global south, maybe getting more traction on issues like climate finance if the West is more unified.
And then there's the people angle, the diaspora, students.
Right. Huge Indian diaspora in both the UK and EU, lots of students going to the UK. If coordination improves, maybe it eases mobility for professionals, creates a kind of semi-integrated talent pool, could strengthen migration pacts India has.
So the main takeaway here is that this isn't just about London and Brussels. This potential reset could really reshape India's engagement with the West, trade, diplomacy, influence.
And for you, this matters because shifts in international relations, trade rules, mobility pacts, they can directly impact opportunities, whether you're in business, looking to study abroad, or just planning travel. It changes the landscape.
Okay, let's move to the opinion section now. We've got a parlay, a moderated discussion on India's nuclear energy laws. This features Ashley Tellis and D. Raghunandan digging into India's big goal, boosting nuclear power from around 8 GW now to 100 GW by 2047. That's a huge jump.
A massive jump. And the core debate is, does India need to change its laws, specifically the 2010 Civil Liability for Nuclear Damages Act, CLNDA, and the older Atomic Energy Act to let private companies, including foreign ones, build and run nuclear plants here?
Ashley Tellis argues, yes, absolutely. He basically says reaching 100 GW is impossible without both boosting domestic capacity and getting foreign players involved. He sees the current liability law as a major roadblock.
He calls it a genuine impediment. Says companies from the US, France, Japan have all said it's a problem. He even points to the Russian company Rosatom, which is building plants here apparently. They needed special contractual agreements back in 2008, before the 2010 law, to get around liability issues. He suggests that kind of workaround isn't really possible now.
And it's not just foreign companies?
No, he says it affected Indian suppliers too. After the 2010 law, apparently domestic suppliers also demanded similar contractual protection from the state-run operator NPCIL, creating uncertainty. He does acknowledge U.S. pressure is a factor, but his point is, if you want foreign investment, the law has to change.
What about supply chains? Can these foreign companies actually deliver?
Tellis thinks so, yeah. He argues Western suppliers will build capacity if the demand is clearly there long-term. On tech transfer, he sees it as mostly a commercial issue, though U.S. rules play a part. He suggests developers of newer small modular reactors, SMRs, might actually be more willing to transfer tech to access the Indian market. Says tech transfer isn't a showstopper.
And liability for these newer SMRs. They're less proven, right?
Tellis points to the International CSC Model Convention on Supplementary Compensation. The idea there is liability mainly falls on the operator. There's a fund set up beforehand. Supplier liability is limited usually only if there's a specific contract or, like, willful misconduct. It aims to get compensation out fast, not litigate blame for years.
Okay, so that's Tellis. What about D. Raghunandan? He's against changing the law.
More skeptical, definitely. He thinks the whole argument for changing the law rests on flawed ideas. One, that lack of investment is the main problem. He disputes that. Two, that other countries are expanding nuclear this fast. He points out slow growth in the West and says China is the only one doing it at scale, but they're unlikely to invest here.
So he doubts changing the law will even attract the investment.
Pretty much, especially from the U.S., given their own industry's challenges. He feels it's mainly an American problem, noting France and Russia haven't pushed as hard on the law itself. He thinks investment follows expected returns, not just legal changes.
And the liability issue.
Raghunandan raises concerns. He's suspicious of companies wanting to invest without liability, suggesting they want to operate but leave the consequences to India. He brings up past political objections to similar ideas, referencing the Bhopal disaster and fears of multinationals avoiding responsibility.
He's also doubtful about tech transfer actually happening.
Yeah, very skeptical. He uses the defense sector as an analogy, years of trying to attract foreign investment and tech transfer, even raising FDI limits. But not much major tech actually came. He doesn't see why SMRs would be different and suggests India should focus on scaling up its own existing reactor technology first.
So a real clash of views there. Necessity of foreign input, impact of the law versus economics, likelihood of tech transfer.
Exactly. It highlights the tough trade-offs in chasing clean energy goals. You're balancing safety, cost, getting the right tech, managing international relations, and building domestic capability. Understanding these liability and investment details is crucial when we're talking about something as critical as nuclear power.
All right, let's move into the tech section. First up, an explainer by Sanjay Vijaykumar on India's Insolvency Code, a critical assessment. This brings us to the economy, specifically how India handles business failures using the Insolvency and Bankruptcy Code, the IBC, from 2016.
Right, the IBC was India's big move to create a proper, modern bankruptcy system. The main goals were to speed things up, shift control from defaulting owners to creditors, and have a clear timeline, remember that 330-day target before a company goes into liquidation.
So how effective has it been? The article cites data showing significant recovery, about 3.89 lakh crore rupees realized, which is around 32–33% of the admitted claims.
And an RBI report called it the main recovery channel for banks recently, almost half their recoveries. Importantly, the recovery when a company is resolved under IBC is way higher than just selling off assets in liquidation, like over 170% more. Resolution plans tend to capture most of the company's fair value.
And it seems to favor rescuing companies if possible.
Yeah, the stats suggest nearly 2 companies get resolved for every one that gets liquidated. But maybe the biggest impact the article highlights is on behavior.
The credit culture change.
Exactly. Experts quoted say it shifted the whole culture. That Supreme Court line, "the defaulter's paradise is lost," really sums it up. There's now a real threat of losing control if you don't pay, which pushes borrowers to be more disciplined.
And there's evidence of that.
Yeah, data shows thousands of cases settled before even getting formally admitted into the IBC process, debtors paying up to avoid it. Studies also link the IBC to falling bad loan levels at banks, lower borrowing costs for struggling firms, and even better corporate governance.
Okay, sounds pretty positive overall, but are there challenges?
Oh, definitely. Big ones mentioned are judicial delays within the NCLT system, even after creditors agree on a plan. This pushes things beyond timelines and risks liquidation for potentially viable businesses.
And uncertainty even after a resolution.
Right. Plus, handling defaults in newer kinds of businesses or dealing properly with things like employee dues or keeping tech going during transition, the framework struggles a bit there. Experts suggest needing better court infrastructure, maybe more use of pre-packaged deals, and clearer legal lines so commercial decisions aren't constantly second-guessed.
There was also concern about a specific court verdict, Bhushan Steel.
Yeah, that apparently worried people because it seemed to question the finality of already approved and implemented deals. The fear is, if things can be overturned later, who would want to bid in the first place? It undermines the whole process.
So the conclusion is, IBC is vital but needs work.
Pretty much. It's the backbone, but needs to evolve, find that balance between oversight and letting business decisions stand.
And for you, the listener, why care about bankruptcy law? Well, a system that works smoothly helps clear out failed businesses efficiently, frees up capital, encourages investment, strengthens banks, and ultimately supports jobs and economic health for everyone.
Okay, next we're shifting focus to a specific region, Ladakh. An article by Vijay Singh, Ladakh, New Policies and Ongoing Demands. It covers recent government regulations and what local groups are still asking for.
And the backdrop is key here, right? Ladakh became a union territory in 2019 after Article 370 was changed, but crucially, without its own legislature.
Exactly, and that lack of an assembly has been a major source of concern for locals. The article focuses on new regulations, just notified dealing with official languages, civil services, the Hill Councils, and importantly, job reservations.
Tell us about the job reservation policy. That sounds significant.
It is. The new rules set aside 85% of government jobs for resident Ladakhis. Then there's another 5% for domiciles non-locals who've lived there continuously for 15 years, but that clock only started ticking from late October 2019.
So with the 10% EWS quota already there, that takes total reservation to 95%.
Yeah. 95%, yeah. Which the article notes is among the highest anywhere in India. The regulations also cover things like reserving council seats for women and defining official languages like Bhoti and Purji alongside Hindi, English, Urdu.
Why were these policies brought in now?
It seems largely a response to protests from Ladakhi groups. After UT status, there were widespread fears about outsiders taking land and jobs, leading to demands for protections like they had before, maybe under Article 35A, which was also revoked.
So groups like the Lay Apex Body and the Cargill Democratic Alliance came together.
Right. And their main demands have been pretty consistent. Sixth schedule status for tribal autonomy, full statehood for Ladakh, separate Lok Sabha seats for Leh and Kargil, and filling existing job vacancies.
So have the new regulations satisfied these demands?
Well, partially. The article quotes a leader from the Leh Apex Body saying the job reservation chapter is now closed, which is a big step. But he stresses that the demands for statehood and sixth schedule protection are definitely not closed. They continue.
So talks are still ongoing with the government.
Apparently so. The Home Minister met with a committee and assured them that other issues like land protection or constitutional safeguards would remain under discussion. But the land issue itself hasn't been formally raised yet, according to the piece.
It really shows that tension, doesn't it?
Yeah.
The government addresses one key concern, jobs, but the push for broader autonomy and constitutional safeguards continues from civil society.
Absolutely. It illustrates those complexities of governing diverse regions, balancing central policy with local aspirations, especially in places with unique constitutional histories. And why do things like land, identity, jobs matter so much there? Because they're seen as fundamental to preserving their way of life and future.
Okay, for our final piece, let's turn to tech. An article by John Xavier in the Cache E section, AI's Unchecked Ascent. Regulatory lag. The title says it all, really. AI is moving way faster than the rulebook.
Yeah, meteoric acceleration is the phrase used. You see it everywhere. OpenAI, Meta, Google, all pushing out new AI features, integrations. Capabilities are expanding incredibly fast.
And what fuels this? Data. Vast amounts of it, scraped from the web, collected from users. That's the lifeblood for training these AI tools.
But that reliance on data is landing them in hot water. The article mentions big lawsuits over data practices, tracking users even in incognito mode, allegedly misusing biometric details, leading to huge settlements, billions of dollars.
Though the companies often settle while denying they did anything wrong.
Exactly. And the article suggests that's strategic. Settling avoids a court judgment that could set a damaging legal precedent for the whole industry.
Even the AI labs themselves, like OpenAI, are facing lawsuits over their training methods.
Yes, specifically about scraping data, including copyrighted material, without permission to train models like ChatGPT. Authors, news outlets like the New York Times, Indian publishers they're suing, claiming theft of intellectual property.
So you have this fundamental clash, the AI industry needing tons of data versus existing protections for privacy and copyright.
And despite all this legal action, the article says AI development just keeps charging ahead, seemingly undeterred. It feels like tech giants are operating almost outside conventional constraints, deploying models faster than laws can even be defined, let alone catch up.
What about regulations elsewhere? The EU's GDPR gets mentioned.
Right, as a serious attempt to control data use with big fines. They're moving beyond GDPR now, too, with things like the Digital Markets Act. They're even targeting firms like TikTok over data exports. GDPR forced some changes, but AI keeps booming. The EU's specific AI Act is coming, but its real impact is still unknown.
And India has its own Data Protection Act now.
Yes, India is navigating that too, trying to balance privacy and flexibility for innovation. China's approach is different, again, strict data rules internally, but heavily supporting domestic AI firms that have access to massive local data sets.
So the core problem highlighted is this speed mismatch, innovation versus regulation.
Precisely. Big tech's innovation cycle is just way faster than the slower, more deliberative cadence of law and ethics. The risk is that privacy and safety become afterthoughts, things you try to fix later, not principles you build in from the start.
This gap between AI speed and regulatory speed is huge, and it affects everyone's data, everyone's future with technology. What does it mean for your privacy, for society, when innovation just outruns the rules?
You know, reflecting on all these sources today, whether it's free speech, nuclear power laws, AI regulation, regional demands in Ladakh, or even global diplomacy shifts, there's a common thread, isn't there? It's this constant challenge of managing incredibly rapid change and balancing really complex, often competing interests.
It really leaves you wondering, how do societies effectively govern all this simultaneously? How do you keep up with tech, with geopolitics, with internal demands, and make sure fundamental principles like rights, safety, fairness don't just get lost in the shuffle? Thank you for listening. You can give suggestions by contacting on Twitter handle given in the episode description. We are always eager to hear what our listeners want to be informed about. We wish you a great day.